I want to take this opportunity again to thank everyone for coming to this year's 2016 annual meeting, basically focusing in on the challenges and innovations and also looking at that through the lens of professionalism. We've already had a rousing start this morning, and it continues now this afternoon. It's indeed a great privilege and pleasure for me to welcome the Honorable Stephen Breyer, GW Law Associate Dean Alan Morrison, and all of you to what I consider to be really one of our capstone events at this meeting today. Ladies and gentlemen and colleagues, I want to tell you, you're in for a real treat. As Justice Breyer and Alan Morrison, GW's Learner Family Associate Dean for Public Interest and Public Service Law, will engage in what I guarantee you is going to be a memorable conversation that intersects with many of the themes that we have in our meeting for the next several days. Let me say a few words about a gentleman who really we all know, but I'm going to try to add a few tidbits that really define what a unique individual he is. Justice Breyer was appointed to the U.S. Supreme Court in 1994 by President Bill Clinton, and quickly cultivated a reputation as one of the most pragmatic justices on the bench. Long before taking his seat on the Supreme Court 21 years ago, he was a law professor at Harvard Law School, where he specialized in administrative law and wrote a number of influential textbooks, that many of which are still in use today. Prior to his Supreme Court nomination, he held a number of other prominent positions, including Special Assistant to the U.S. Assistant Attorney General for Antitrust, Assistant Special Prosecutor on the Watergate Special Prosecution Force, Judge on the U.S. Court of Appeals for the Fourth Circuit, and Chief Counsel to the U.S. Senate Judiciary Committee. I would be remiss if I wouldn't add one thing that is seldom put in his public or published bio, but I discovered by combing through the internet with a great degree of intensity. And that is, he is also an Eagle Scout, which comes as no surprise to me. Joining Justice Breyer on the podium today is an individual whom I've gotten to know very well in the last year and a half I've been dean at GW, and certainly I knew his reputation long before that. Dean Alan Morrison is, as I said before, our Associate Dean who's in charge of doing a lot of what I consider to be one of the cornerstones of what is really redefining what we're doing for our students today, and that is engaging them in public service, something that has been underscored by all of the things that we need to do in order to make our students much more responsible and also instill in them a sense of great professionalism. He's worked for the Public Citizen Litigation Group, which he co-founded with Ralph Nader in 1972, and directed for more than 25 years that very organization. He is a longtime friend of Justice Breyer's and has argued 20 cases before the United States Supreme Court. At GW, he teaches civil procedure and election law and does an extraordinary job of creating pro bono opportunities for our students, bringing a wide range of public interest programs to the law school and encouraging students to seek positions in the nonprofit and governmental sectors. He is a graduate of Yale University and Harvard Law School, served as a commissioned officer in the U.S. Navy, and was an assistant U.S. attorney in New York. Ladies and gentlemen, it gives me a great deal of pleasure to present to you Justice Breyer and Associate Dean Alan Morrison.
So when I told Justice Breyer that we were going to have this conversation, I said to him, there are three things we're not going to talk about: cameras in the courtroom, collegiality among the members of the court, and the presidential election. So I want to begin by asking, why do you write books at all? This is what, your fourth book now that you've done? You
Ask them the same question.
You get plenty of opportunity.
I mean, there we are.
But you have life tenure.
Yeah, but you know, they understand it.
But
you
you
just
write-
get going here. I mean, we wouldn't be. I was a professor for quite a long time. I wouldn't have been in that job, and you wouldn't be in your jobs unless you like explaining things to people. Isn't that true? I mean, we learn things, and you like to explain them. And we can't control it if they want to benefit or not from what we explain. That's their problem. But my goodness, that's what we do. So stop me before I write again. I mean, you know,
You get to explain things in 8 to 10 majority opinions every year, and as many concurring and dissent opinions as you choose, right? But this is more.
In a sense. In a sense. What Harry Blackman told me when because he was my successor in that particular seat, he said, "You're going to find this an unusual assignment." And he was right. It is an unusual assignment. And so what I can do, or what I can try to do, is I see things in our profession, because of luck and a lot of other things, from an unusual position in an institution that's important to this country. And so that's what I want to explain. And the best way to do it, given my own abilities or background or whatever, is not necessarily to go out and say, well, this morning I got up and went to the court and then I opened up my word processor, etc. It's not my day at camp. The best way for me to do it, as often the best way for you to explain law in general to a first-year class, is to take a subject. And you take a subject and you go through the whole thing. And what you are doing in teaching that subject is you're really teaching something about law, and you're teaching something about American life, and you're teaching something about how we live today, yesterday, tomorrow in this country. All right, I'll try. And so I've written actually 3 books about the court. I've written on administrative law. You know, the New York Times, not New York Times, the LA Times got a hold of my book on regulation. I'm very surprised you can't just cite the title of that immediately. But the LA Times got a hold of that book, and the review started as follows. In Alice in Wonderland, the Dormouse and Alice emerge from the pool of tears. The Dormouse begins to read from Hume's History of England. Why are you reading that, says Alice. Because, says the Dormouse, we're wet. And this is the driest thing I know. That was before. Okay. Well, all right.
Didn't I write a blurb for that book to say people should read it?
Yeah, you did. That was great. That was a true act of friendship, and I appreciate it, because we've been friends a very long time.
It's an over-the-counter sleeping pill, right?
It's a very interesting book.
Important.
But I'm not, all right, there we are. But these 3 that I have written about the court from different points of view are for you. They're for your students. They're for 99% of the public who are not lawyers.
So tell me about the decision to write the book. The book is called The Court in the World. I happen to have a pre-publication.
It's a rather non-pretentious title, The Court in the World.
It has a much prettier cover now. And by the way, Justice Breyer will be signing books in the back there after the program is over. So hope you'll take advantage of the opportunity. So what made you decide to write a book about the world in the court, as you call it?
We take that in because I've seen something happen in 20 years that I think is interesting, that I think reflects the world, and I can only write about it from a very narrow point of view, but it is a point of view that we share. And that is that there are a lot more cases in the Supreme Court that require us, in deciding them, to know something about what's going beyond our shores. Now, I say that particularly with a vagueness, because I don't want to say citing foreign cases or not citing foreign cases. That's an aspect of it, but it isn't the aspect. What's the aspect? Well, I'll put it this way. Very good novel, Charterhouse of Parma, fabulous novel. The hero, Fabrice Del Dongo, at the opening is at the Battle of Waterloo. Bullets, horses running back and forth, smoke. Napoleon is going back and forth, and he's thinking to himself, Fabrice Del Dongo, something very important is happening here. I wish I knew what it was. You see, when I hear words like globalization, interdependence, the shrinking world, or put it in whatever cliche you want. I have the same kind of a feeling. So I thought it might be helpful to be quite specific by showing different categories and problems of cases that do arise with increasing frequency through subject matter, highlighting how they're decided and what the problems that I see are with the way in which we've decided them. Why? Because I have an answer as to how to improve it? I don't, actually, and that isn't false modesty. But trying to stimulate conversation among people, if I'm talking to this audience, who will know more about any individual case than I know, because they'll be specialists. But they won't necessarily be seeing the relationship to, if it's over here with human rights and the Alien Tort Statute, over there with copyright and the question of whether you have to or can have the power to sell the books you want when you bought them from Thailand in a shop and brought them over here, and the publishers stop you from cutting the price or not. What's the relationship? Foreign, that's the relationship. And more than that. And so I do see something you don't see, which is because of my daily job. So that's what I want to explain. And I hope by the end of it, you will think there's something rather big going on here. And that something rather big, at this time, for you, perhaps, or for others, will lead you to say or think about the openings there are to reproduce what has been the traditional relationship between professors, judges, and lawyers, which I can go into later if you want.
So if you had your druthers, what would you suggest to law professors do with this book and how they use it in their classes, recognizing that we have people teaching virtually every subject that's taught here, and the book covers substantively a number of subjects, but it also covers them all in a global context?
Well, the first thing, my cell phone is ringing. I know what it is. It's a call from my publisher who says, tell them the first thing is to buy the book.
You don't care whether they read it,
no,
just buy it.
Wrong. I said it was the publisher. Yeah. The fact is, what I'd like is people at least to look at it, to look through it, and to think about, does this affect me? Does it affect my students? If I'm teaching contracts, is there something in a contracts course that it might be helpful to be able to give my students the ability to understand the possible importance in their practice or later of the contract law of France, or the contract law of Europe, or the way in which they interpret a contract, or the way in which they use expert witnesses, and the power that the judge has to decide who will be the expert and listen to that expert. Look at the Yahoo case, a great case involving France and the United States, and whether or not, I mean, it involves everything. And to be familiar with that, and if you're teaching a tort class, or if you're teaching whatever class it might be, it's not something that I used to have where we had Roger Fisher, who was a great teacher, but he was in a course called International Law. And everybody took it because it was viewed as a gut. Now, that's not a reflection on Roger Fisher. He was a great teacher. But that isn't today's world, those boxes. At least it shouldn't be, in my opinion, insofar as something international is at issue. And the most I can do is to present to a public that's too ready to put things in boxes, in my opinion, a general picture of what's going on in the court in cases, maybe 15%, maybe 20%, that require you to look beyond our own shores in many different ways. And there it's the examples that matter.
So, a number of instances you talk about foreign law being relevant, and in I think it was the Hamdi case, you talked about how practices in Israel and in the United Kingdom were bearing on you. And both with respect to the actual practices and with respect to the law, do you worry about getting it right? That is, we have enough trouble understanding what's going on with our own legal system. How do you get the facts about foreign practices, and how do you get the law about foreign countries? And do you worry that maybe they're coming in through parties that have an axe to grind, or they're amici on one side or the other, and you may not be getting them right?
There's a sense in which it is important to get it right, and it's hard to do, and a sense in which it isn't quite as important as you might think. Very rarely, though sometimes, very rarely is the decision of a foreign court going to bind us.
Yes.
And particularly not in the cases you mentioned. You would like, where you, to understand, I think, in those kinds of cases, which is the case of the security versus civil liberties, which is a very important kind of case, you would like to be able to understand what practices are relevant that are going on overseas. And it is important to get that right. But that isn't a different problem from the problem of getting the ERISA law correct when someone is in a state court. And I'm just thinking of a particular case which I can't remember the name of, but my God, it was a complicated ERISA case. And I felt that I didn't understand it, and I might still not understand it, until I read a brief filed by a section of the California State Bar that specialized in ERISA and real property law. And when I read that, I thought, my God, that's the answer. And I thought, of course, I was in dissent. But the fact is, why didn't they get there sooner?
Right?
Why didn't they get that sooner? Up to the Secretary of Labor, who would have told the Solicitor General, and maybe the whole thing would have turned around. Now, in other words, that's an endemic problem. You want to go back to your problem of the big problem. And what I've done in the book is I've set it out in a way where I want people in that particular kind of problem. Security, constitutionally given the power to protect us to the President and the Congress. They're in charge of security, constitutionally speaking. But conflict with traditional civil rights. And their judges certainly have a role to play. And so what happens when these two conflict? Now, that's a very old question. And the reason that I put it in is because until fairly recently, the answer to that question was called Cicero. Cicero said, in time of war, the laws fall silent. Actually, I had a better translation. I used to translate it as, when the cannons roar, the laws fall silent. And then somebody pointed out the Romans didn't have cannons. But still, you see the point. Now, go through the Civil War. Lincoln and his cabinet put tens of thousands of people in prison. The Secretary of State calls in the British ambassador and says, I can push this bell here and put any person I want in New York in prison. This one, any person I want in Indiana. Tell me. Does the Queen of England have such power? You see? Oh, of course the courts got into the act after the war was over. But for, by occasional exception. World War I. Try and see what Wilson did. World War II. We know the instance of the 70,000 Americans of Japanese origin taken from their homes with zero evidence, and put into camps. For 2 or 3 years, he comes to the court. And I once met Fred Korematsu, actually. He was, because our next door neighbor in Cambridge was the daughter of Ernie Bezig, who used to run the ACLU in San Francisco and played poker with my dad. And so she had visiting her Fred Korematsu, the hero of this Korematsu case. And he had thought, of course, this is America. They can't make me, a citizen, go to a camp. He was certain he'd win. Bezig represented him. He lost. Why? He lost 6-3. It was Black, Douglas, Frankfurter, the civil libertarians, the ones who later decided Brown versus Board. I think, this is my own view, that really, I think we'd all say now, wrong result reflected the fact that someone has to run this war. Us or the president. We can't. So Roosevelt has to. Therefore, he wins. Well, that went a little far, perhaps very far. So now we have, which I think is a great case. I'd love to see this taught a lot. The case of, fabulous case, the steel seizure. Incredible case. Because there Jackson, who really took the laboring oar in this, is going to cut off Roosevelt's power. And it's much easier to do now.
Truman.
No, that's why it's easier to do.
Oh.
You see, Roosevelt isn't there anymore.
Right.
and Truman isn't quite as popular. And so they say, no, you've gone too far. You've gone too far. Very interesting. Well, in conference, you say, but you, when you were Attorney General, Justice Jackson said the president could do this kind of thing. He says, yeah, but I was in a different job then. Read what Biddle says. Now, why go into all that history? Because of steel seizure. And because steel seizure and other things, perhaps, turn something around. So that when we get to the cases you started with, Hamdi, the 4 Guantanamo cases, they're all won by the inmates. They're all won by the detainees, all 4. And the government loses every one. Those 4 are
not big losses, but losses.
Yeah, correct.
So,
and look, again right now, but I'd say, just think of those 4. Not the most popular. Bin Laden's chauffeur, not the most popular guy. All right, so he wins, president loses, but the key line, Sandra O'Connor. The Constitution does not write a blank check to the president, not even in time of war. Now, that's what all this long thing has been leading up to, those 6 words or 7 words. Why? Because I want to say that's where we are, and as soon as I say those words, immediately pops into your head, no blank check? Fine. What kind of check does it write? Okay. And there we are. And what a pity that I can't really answer that question very well. I can give some, and people criticize our decisions on that nonstop. Why didn't you lay down a list? Why? Because I don't know what should be on that list. Well, why didn't you let the president do what he wants? Really? You want to go back to Korematsu? Is that what you want? Oh, well, isn't there an intermediate choice? What? So I'm trying to set a stage. And there we are. And I say, well, hey, I am in a profession which I am not the only part. The judges are there. The professors are there. The practitioners are there. Traditionally, judge makes a decision. Law professor reads it. We hope, I'm keeping my fingers crossed. The law professor reads it, writes the treatise or article, puts it up against other things because he or she's a specialist, and criticizes. That's the job, you criticize. And say, do it this way, do it that way. Practitioner reads the article, takes whatever's going to help his case. There's some other ones helping the other side. We're represented with what's been done, and then perhaps we reach a better decision, which will then go through the same iterative process. That's the classical thing. So, a long answer, but I'm throwing this book into that whirlpool. And I hope that it has a little traction, if I'm lucky, and that it will lead somebody to start thinking about how to improve that situation.
when you discuss the Youngstown case here in your book, you spend a lot of time talking about the backstory. Do you think that law professors should spend more time talking about the backstory in cases when they're trying to explain what the outcome is? I know it wasn't just Youngstown, but Youngstown was the most pronounced example because it was the largest one. But in a lot of other cases in the book, you talk about how things that don't readily appear on the opinion, or you've got to dig for them to come, really did influence the outcome. I've always thought that, for example, in Youngstown, the fact that Truman could have stopped the strike by letting the wages go up the next day, or letting the steel companies increase their prices the next day, always had a bearing on the willingness of the court to go along with Truman.
Yeah, he was told, Truman, by his people in charge, Charlie Wilson, Electric Charlie.
Electric Charlie, not Engine Charlie.
Yeah, he was told that if you do this and break your price thing, you will see prices going up all over America, and that's going to create a pretty bad inflation, which we don't want at the time of the Korean War, which was going on. So, yeah, maybe not. I mean, the story there to me shows there's nothing obvious. Nothing obvious. Truman's decision wasn't that unreasonable, in my opinion. But the court did think that. Now, why tell the backstory? There, I think the backstory is important. Why is it important there? It might not be in an ERISA case. Probably isn't. But it probably is there. Because I think the truth of that area of the law was well said by Justice Jackson when he said, because I've had to look up a few of these, as many of us have. He says, when you look to see what the founders thought, and I would add to that what the prior cases hold in respect, in this big area, security versus the inherent powers of the president, the inherent powers of the president. When you look to see, I say, what the cases hold, what the precedent says, what the founders thought, he said it's like Joseph interpreting the dreams of Pharaoh. Yeah, that's right. I mean, you try it. You try it. That's what we had a case not too long ago that was something like that. That was the case of the president's recess appointment power. What law is there on that? All I can say is no matter how little you think there was still less than that.
But there's plenty of law now.
Yeah,
You
yeah,
read all
but
those
that's
opinions,
the job.
88 pages of opinions. Yes.
No, that's the job. That's the job.
That was
and that isn't true in an ERISA case. And that, so I'd say it depends on what the area is, and it depends on what you want to do in your class with this material. And that's why I say I'm part of a moving system. And that system, as I've said 5 times already, includes the teachers. It includes the practitioners. And somehow, through that interaction, we've done all right so far. Does that mean we'll do all right tomorrow? I don't know. And that, all right, that's a little corny, but it's true. It is what I think. And so my contribution to this can be in writing the book, is where we started here, can be the same as when you teach a class. You're trying to throw out material, put ideas in front of people, see how they react, modify accordingly, etc. And this will, I think, produce a number of areas, a number of cases, a number of concrete examples, so that my hope, by the time someone finishes reading it, is that he will understand better than before what this term globalization, internationalization, looking beyond your own shores, what it might mean for an institution like ours, which is also like yours.
You generally approve the movement of the court away from Cicero and Korematsu to greater involvement in the Guantanamo cases. Before the book was finished, the second round of the Ziv Tovski case had not been decided yet. Ziv Tovski is the case in which the Congress passed a law requiring that the State Department put on passports of individuals who are born in Jerusalem that they are born in Israel at the request of the parents, in this case, of the child. And they made such a request, and the State Department refused to honor it, said it violated, it was unconstitutional. Your first opinion, you were all alone in saying it was a political question. And then you agreed with the president. We'll come to that in a moment. But I'm curious as to why it seems to me to be quite everybody, including those who are most inclined to find ways not to decide cases on the court, went along and said it was not a political question, that the court had to face it. Is that consistent with your general views that it's better that the court, rather than the president, have the final word?
You could draw the conclusion in a case where I am alone in dissent that I'm possibly wrong.
I would never say that.
I hesitate to draw that conclusion, but nonetheless, I think it's an example in my own mind.
You were the lone dissenter in Clinton versus Jones, as I recall, also. Is that right?
It wasn't quite a dissent.
Close.
Should have been. Yeah.
So what do you... I mean, the president...
Holmes, I think, had a good perception when he says, of course, every legal principle at some point runs into some other legal principle, right, and then you're stuck. I mean, I didn't think that the political question doctrine is dead. I don't think it's dead. I certainly don't think it has a case in anything coming even close to traditional civil liberties, where this was nothing to do with traditional civil liberties at all. And nor is it a case, so much less the case of
election,
Guantanamo, or I mean, you know, something like that. But this was a pretty narrow case involving whether Congress has the power to tell the president to put in a person's passport, if he is an American citizen born in Jerusalem, Jerusalem, comma, Israel. And my point on that, which how odd it is, I usually remember my own points better than I remember the points of the other judges who have written other opinions. But my point in this was that could have a significant effect on the Arab-Israeli situation. I don't know. I don't know. I mean, who knows I don't know how all that is working out, or what they take as seriously or what they don't, but maybe that would be viewed as some kind of serious change in the situation of the American recognition of the borders of Palestine, Israel, etc., or maybe it wouldn't. And what I did know is that the Department of State would tell us that it would, and the people on the other side would tell us that it wouldn't. And I read both of those, and I thought those are their honest opinions. Fine. I still don't know. And so I think this is the kind of question where you see the possibility of a significant foreign affairs impact where there was virtually very little at stake. I agree that Mr. Ziv Tovski would have been happier if it had said Jerusalem, comma, Israel. And I agree that people in Congress did want that to happen. But it is not a question, if we stay out of it, that there's some individual rights that will, in fact, have protected rights that would be injured, etc. So I thought it's, in a way, Custer's last stand, and there we are. I thought the political question did play a role, and I did not see that as inconsistent with saying that, indeed, we should be in the business of protecting major civil rights, even in wartime. And how they're protected in wartime, to what extent words like reasonable search and seizure, to what extent a deprivation of liberty without due process of law, even to what extent something does or does not fall within the words, the freedom of speech. All those are questions that will have to have answers if you take my approach, which is the majority approach there. And therefore, we will have to have ways of answering them other than just listening to two people who say opposite things and we're paid by their clients to write these opposite things. Now, that is a problem. And that's the problem that I'm posing. And that's the problem that I don't want to have answered by saying, take that political question and go back to Korematsu. I think that would be a terrible answer. And I think to answer too much too quickly would also be very risky. And by the way, it's not going to come up, I suspect, not just with putting people into prison like Guantanamo. I mean, I do read the newspapers. There are questions of Fourth Amendment obtaining information from people. There are questions that are going on, certainly in other countries, of what you could or would not say on the internet. There are questions that conceivably do bring into new contexts very old constitutional dilemmas that have been solved in some situations, but not others. So in that area, that kind of question, I think is important, and thought has to be, and will be, but I hope more broadly we'll get answers. That isn't the only one. There are commerce problems. There are treaty problems. There are problems after problem. I don't know what else you want to go into there.
Well, I'd like to talk to you about your approach to interpretation. On page 240 in the third paragraph, you say you use text, history, precedent, purposes and values, and consequences. Is there anything you don't use?
That's a good question, and it's sort of.
And do others?
I'm glad you read this so carefully.
I had a big assignment here, you know.
Yeah, you're right.
I was tough. And do you think that your fellow justices use them, the same list? Is it use them all the same way in the same cases? Do you use them? Do you put more in, as you suggested a moment ago, in terms of consequences than some of your colleagues might? And how should we think about that as teachers trying to teach our students how to think about how these cases get decided and and how to argue in the next case?
Well, we're a statutory court. We deal with statutes. Most courts do now. And we're interpreting a text. We're interpreting some words on a piece of paper. And there are, at least if it's in our court, several different interpretations that are pretty difficult to say which is which. We take cases where lower courts come to different conclusions on the same matter of law. So they're good judges. If they've reached different conclusions, there's all likelihood there's going to be different reasonable interpretations of those words. Now, I do believe all judges, I think if you look into it, I think all judges do in fact use those 6 factors. The first thing they look to is the text. Now, the text doesn't always answer the problem. I think it usually doesn't in our court. But if the text says fish, that does not mean a carrot. A carrot is not a fish. The text does put limits on what you can say. And history, tradition, what's res ipsa loquitur, if anybody, I mean, what is habeas corpus? Indeed. And what was the history in which this statute emerged? Indeed. Precedent? Again, the precedent doesn't answer the question normally, because if it did, why is this case here? Consequences, I think very important. Consequences, not any consequences in the world. I want to know purposes first. There was some human being who wrote those words. Why? What was the object? Given the statute, what was the object? Purposes. They always have a purpose, those words. And similarly...
is that Hart and Sachs? Is that...
Yes! Of course it's Hart and Sachs. If you want to know what a judge thinks, go find out who his teachers were. And that's what he thinks. And the fact is that those some people, like Nino Scalia, for example, puts more weight on text, history, tradition, precedent. And he says, I never use purposes or consequences. And I say, but I found a whole article here where you wrote about the use of purposes and consequences, and you seem to think sometimes that was good. And you'll say, well, sometimes, all right. And I will say, absolutely, I use the first 4. Absolutely. So I think the differences between us within the court, insofar as they're general, are often a question of how much weight you tend over time to put on purposes and consequences compared with tradition, history, text, and precedents, and how much weight you try to put on the first 4. And he'll say to me, you know, the way you act and put all this weight on the purposes and consequences, it's just doing what you think. I'm not saying you do it, Stephen, but I'm saying there's a risk in this approach, and we've talked publicly about it. The risk in this approach is that the judge will substitute his subjective opinion of what is good for what the law is. And that way lies chaos and politics, which is a way of eventually earning disrespect for the courts. And I'll say, yes, I understand that risk, but I think by explaining things and what I do, I can stay away from it, or stay far enough away at least not to run into the other problem, which is to create a set of statutes and interpretations that is so rigid and so far removed from the problems that people have today that who would want that statute or constitution if they had a choice? So there are risks on both sides, and there are arguments on both sides, and we'll talk about it, and then it turns up. Those differences will often turn up in individual cases, but I think those kinds of differences really play a much greater role in reaching different results than anything that would normally be called politics.
You mentioned earlier on the copyright case involving the first sale, the Chinese student from Taiwan who bought U.S. published books which are sold in Taiwan for a much lower price. He brought them back in the United States and he sold them for a profit. He got sued for copyright violation, and the majority upheld his claim that the first sale doctrine applied and that he was entitled to do that. And in your discussion, you talk about the consequences of the opposite result, what it would have been, and that seemed to be a factor in your decision. And there's a suggestion there that if you were wrong about the consequences, that Congress would step in and fix them. So my question is, first, do you think about Congress stepping in and fixing things? Is that a realistic thing these days? Is Congress paying any attention to these kind of statutes? Or should you put that off to the side because they can't fix anything these days?
No, I don't think that these days comes into it. I think very little.
So you have to think of it as the legal authority to fix
That's a good question, to which I think there's not a precise answer. The copyright case was a case in which a student from Thailand at Cornell discovers the same textbooks are being sold much cheaper in Bangkok. So he writes to his parents and says, send me a few. And they sent far more than a few. And he began to sell them. And the publisher got a little annoyed and brought a lawsuit. And the question was, does something called the first sale doctrine mean he has every right to do that, to sell them? And the words that are going to answer this, well,
No.
you turn to those words and you
No,
say,
not
well, you didn't write them.
I didn't write them, no.
Oh, but my God, they're pretty hard to work out. And so ultimately, the thing that I found interesting, particularly interesting for present purposes, is the fact that I received a stack of briefs like this. And they were from lawyers all over the world. They were from governments of foreign countries. And I'm thinking, why do I have all these briefs in this technical case? The answer, which one explains, is copyright today is not just a question of books, films, and music. It is everywhere. Cars, automobiles, software, copyrightable. Go into any store you want. The products have labels. The labels are copyrighted. And we're told in there that our answer, in this case, is going to affect $3.6, maybe it's $3.2 trillion worth of commerce. That's a lot of money.
You had a prior case on that. It involved jewelry, I think, that was copyrighted. One that was deadlock 4-4, and then before you came back and said.
Yeah, but I'm talking about the amount of money.
Oh, yes.
Consider the amount of money of commerce in today's world, and of course we have to have those briefs. And of course you have to know something in a copyright case of how foreign countries behave, their publishers, et cetera, et cetera. All right, so you say, now, did the consequences matter? Yes. And I wrote the opinion in that, and actually Ruth and I, which we don't usually, but we were at odds on that one. And I thought that those consequences mattered a lot. And you can see why if you read the opinion.
But of course, it mattered.
So now the question is, well, could Congress have fixed it up if it were wrong? I mean, we've always thought, for example, I used to teach antitrust, and I think antitrust is an area where if the court made an error, a Congress wouldn't fix it.
Wouldn't.
Would not. But I've always thought that. I mean, I've thought that since 1967, and probably because Don Turner told me that.
Why antitrust?
Now, why?
Why?
Because antitrust is such a basic statute and it's been around for such a long time, and it so much depends, or has depended, on the maintenance of competitive markets in this country, that I think Congress would hesitate a lot to start monkeying around with anything fundamental in that statute. Similarly, try Section 1983, say, or try portions of the Social Security Act. On the other hand, ERISA may be an easier one, because no one understands. Well, but the question I don't think only has a vague answer, and because it only has a vague answer, what you find in the opinions, I think, are people hesitating to say, well, Congress could fix it up, because the answer is sometimes they think they could, and sometimes they think they couldn't. But Ruth, for example, in the Ledbetter case, made a huge point of that. And she was right. And they did change the statute. And so I don't have a good answer. The answer is sometimes I think it is a factor that goes into people's minds, and sometimes I think it isn't.
In the last section of the book, you talk about the judge as diplomat. That is, in both directions, with foreign judges coming to the United States and U.S. judges going abroad. Do you do a lot of that work yourself, and both here and abroad? And tell me what you hope to gain by participating in those kind of processes. Not gain for yourself, but in terms of
some. You guys, some. You can. I think it's important, but you can't really make much of a dent I'll give you an example of why I think it's important and try to make a dent. What are you trying to make a dent in? I mean, sometimes I'll actually learn something. Sometimes information is exchanged. I've given some examples of that. But I think it's more than that. And I think it's the same kind of thing if we're, say, in the practitioner or if we're, say, in the world of teaching, wherever we are in the law. I do believe that there's an incredible need in this country as well as abroad to explain to the high school students or the college students why we do what we do and why it's important to them and why they have to be less cynical and why they have to accept what we call the rule of law, all of which is terribly corny. But, example, I am in Washington. The State Department now, through Skype, can connect me all over the world. And they did ask me to give a talk or to Q&A with a law school class in Tunis. Fabulous, fabulous. I sat there for an hour, and as you know, when you start talking to a group of students for a while, you can, after maybe 15 or 20 minutes, you can get something going where the barriers begin to fall and you begin to communicate more directly with them. And that was going on, and I thought we were making some headway here. It was interesting, you know, what do we do, and blah, blah, blah. But then one of the women came up and she said, you protect religion. I said, yeah, the Constitution does. And, well, what if the religious is very, suppose it's sort of basic and they don't want you to do things you think you should do. The light began to dawn. I said, you mean you're afraid a group of fundamentalists will get into power in Tunisia and they'll stop you from going to law school? She said, exactly, exactly. And then a few of the other women came up and we got into a pretty interesting discussion. And of course I'd say, well, I don't know what to tell you. I can tell you I certainly hope you win this one. I can tell you I'm on your side. That doesn't going to help you. But you're going to have to figure out how to do that. That's a problem you have, that you have millions of people here sympathizing with you. They'll do what they can. And we were talking about rule of law. We're talking about that problem that they have. We're talking about them writing a new constitution. Now, I came away from that sort of thinking, oh, my goodness. But also thinking, well, I've done something, I don't know what, maybe to suggest to a few people that this rule of law that we have does work sometimes. It's certainly an important value. It's certainly something that we're all in the business of trying to explain to people. Just as when I heard Harry Reid talk about Bush v. Gore, which I was dissenting. And he said the most remarkable thing, and I understood this and I agree with this, about that case is something that is very rarely remarked, which is despite the fact that it's important, absolutely. Affects a lot of people, absolutely. Popular? No, at least not with half the people, or maybe a few, close. But wrong, in my opinion, wrong, in my opinion. People did not throw stones. They did not shoot each other. They were not out there rioting. Now, when I tell that to an audience of college students, I say, I know 20% of you are thinking, too bad there weren't a few riots. I said, I know that's what you're thinking. So turn on the television set and see what happens in countries that decide things that way, as opposed to accepting a decision that they might think is unpopular, wrong, etc. And I tell that story a lot because I told it to the woman who is the Chief Justice of Ghana, who wants to know why do people in the United States, why do they follow what we, the judges, say? And I say, I don't know. But I do know. I do know that it's a history. And it's a history with lots of ups and downs.
You wrote about that in the Cherokee case, right?
Correct. All right, now, you see? And I want her to come away with the idea, which I'll say, it's not the lawyers and judges you have to convince. It's the 99% who aren't in the villages. That it means sometimes you have to follow a decision you don't like, which could even be wrong. I'm not saying always, but sometimes. And that's part of it. And then I say, hey, we have the same problem here. I hate to tell you, it's not so clear that we don't know what the future will be like. So we have the same kind of educational problem. We have the same problem of going to the editorial boards. We have the same problem of convincing the journalists who aren't lawyers so that they will understand what they're writing about, or the high schools, or the colleges, or grammar schools if you want. And that's whose problem? That's everybody's problem. You see, and that's the kind of thing I think you can make that much progress on sometimes if you're talking to a foreign audience. But I think making even that much progress on that subject is worth it.
So the last question I'm going to ask you is not about the book, but about an issue that's been raised, which is, should the Supreme Court justices continue to have, in effect, life tenure and have control over when they resign? Should there be an 18-year term, as has been proposed, with the president having an opportunity in the first and third year of his or her term to appoint one justice, so that you can't decide, for example, when you want to retire because of who you think the president might appoint or not appoint? What do you think about that as a proposition that...
No, I don't want to say a particular plan, but I do think that if there were a long term, I don't know if it's 18, 20, something like that, and it had it fixed, I'd say that was fine. In fact, it'd make my life a lot simpler, to tell you the truth. It would. And it would.
No one would ask you when you're going to retire, right?
Correct. And the thing you don't want, which you don't want, a term that is so short that the person's sitting there thinking about his next job. Absolutely out. And as long as you can overcome that, then fine. But the problem is, would it require a constitutional amendment? You don't want to open up a whole lot of things that might lead to other things, so I haven't, put that on the front burner, so to think of things that I feel there's a big possibility of changing. But nonetheless, the answer is fine.
Well, I want to thank you again on behalf of the AALS for coming here and being so full and frank with your opinions. And now you're going to have an opportunity to sign books in the back of the room. Can we all give Justice Breyer a great hand?